moving on to the third subsection of our rules. This is all about client confidentiality. Here, client confidentiality is going to make up 6 to 12% of your total MPRE exam. Here, I want to give you a plan of attack on how I would handle this subsection if I were preparing for the MPRE. What this subsection covers is the rule regarding attorney-client privilege, as well as the rule regarding client confidentiality. It also covers the exceptions to both of those rules. There are 4 exceptions to the attorney-client privilege, and there are 6 exceptions to client confidentiality. What you're going to find is that MPRE questions like to test if you understand the rule regarding attorney-client privilege and the rule regarding client confidentiality, as well as each of their applicable exceptions, as well as to see if you understand the differences between attorney-client privilege and client confidentiality. So that's going to be our focus. We're going to talk about each rule and its exceptions. And that's why I would recommend you study this subsection to perform your best on this portion of your exam. So first and foremost, I want to start by talking about the attorney-client privilege and the rule. So here the rule says that the attorney-client privilege is an evidentiary rule that prevents a court or governmental entity from using its powers to compel the revelation of confidential communications between an attorney and a client or agents of either. So let's just stop there. We've learned from the plain language of this rule that the attorney-client privilege is an evidentiary rule. It basically protects communications that are confidential between attorney or its agents and clients or their agents, and it protects the attorney from having to divulge or reveal this information, say by a court ordering it to, or some sort of governmental entity asking them information that would fall under the attorney-client privilege. It's also good to know, since we're talking about the plain language of this rule, is that this rule uses the word confidential. It specifically says that this is an evidentiary rule that prevents a court or governmental entity from using its powers to compel the revelation of confidential communications between an attorney and a client. So here, the big key takeaway so far is that it's an evidentiary rule that's protecting the attorney and the client's confidential communications from having to be revealed. When I say the key takeaway is that these communications must be confidential in nature. So what does that mean? This means that the parties must reasonably believe no outsider is hearing their conversation that's going on. It's also helpful to know that if there is someone present during this attorney-client, say, conversation or communication, and that person is present because they are necessary, then that communication is still going to be deemed confidential or privileged in nature. So, for example, turning to one that's in our outline, it says, if a client brought her accountant and an attorney had their legal secretary present to take notes, and there was an interpreter there to interpret the client's foreign language, confidentiality is not destroyed. Why? Because if I need my legal secretary in the room to take some notes and we need an interpreter present so that, say, I can effectively communicate with my client who speaks a different language, and maybe we need my client's accountant to be present because maybe the legal matter I'm handling requires me obtaining information from this accountant. That means there are more people present in my office than just myself and my client. But that's okay. Our communications are still going to be confidential and therefore still privileged because those other people present are necessary for us to be able to communicate. However, if, say, we're having a conversation at a coffee shop or at a restaurant or in front of third persons who are not necessary to our conversation, then those communications between us are not considered confidential in nature and therefore are not privileged. So now that we know what the attorney-client privilege is, it's an evidentiary rule that protects our confidential communications from being, divulged by powers of, say, a court. It's good to know what is not protected by the attorney-client privilege. So here the rule says that generally the identification of your client as well as your fee agreement that you have with your client are not going to be covered by privilege, absent some sort of exceptional circumstances. And just think about it for a second. This makes sense. We have a whole bunch of rules, many of which we've already discussed, regarding how we are to enter into fee agreements with our clients and what types of fee agreements are ethically permissible. But if our fee agreements were in fact privileged, then we couldn't be regulated regarding our fee agreements. Because if a court inquired into what type of fee agreement we had with our client, we wouldn't have to tell them. So as you can see, that doesn't make a lot of sense. So just to recap, the identification of your client and generally our fee agreements that we enter into with our clients are not going to be considered privileged, meaning that is information, if asked by, say, a judge, we would have to explain or divulge. Additionally, pre-existing documents and evidence are also not covered by privilege here. And just think about the basic definition of attorney-client privilege. It says that it protects confidential communications between the attorney and the client. So pre-existing documents or pre-existing evidence does not fall into that basic definition of confidential communications between attorney and client, and therefore they're not covered by the privilege. Turning to an example in the outline, it says that a client hires an attorney to defend her in a defamation case. There were multiple letters sent between the client and her friend that tended to show the client was guilty of defamation. The client hands the letters to the attorney. These items, the letters, are going to be discoverable because they are not confidential communications between the attorney and the client. Rather, they predated that attorney-client relationship and therefore are not privileged. A few other things to know about privilege before we move on to the exceptions. I would understand that the client gets to hold the privilege. This means that your client can claim privilege or can waive privilege because it's theirs to do so. They are the holder of it. The lawyer, however, does have a duty to invoke the privilege if the client is not there to claim it. So again, it's an evidentiary rule that we as the attorneys can claim on behalf of our client, but if your client is present and wants to waive it, that is theirs to waive if they want. Additionally, the privilege lasts forever. It's going to survive the termination of our attorney-client relationship, and it even survives death. This means that any confidential communications you have between yourself and your client remain privileged even after they fire you or even after they die. So now let's turn to the exceptions. There are 4 exceptions to the attorney-client privilege. The first exception says it does not apply if the client is seeking the attorney's services to engage in or to assist in some sort of crime or fraud. Here an example of this is if the client sits down in the lawyer's office and tells the lawyer that he or she needs help lying on his business loan application. This communication would not be privileged because the client is engaging that attorney to commit a crime or a fraud. So that communication is not privileged. The second exception to privilege says it does not apply to communications that are relevant to an issue of breach by either the attorney or by the client of duties that arise out of their attorney-client relationship. The best example here usually has something to do with, say, some sort of fight between an attorney and client regarding the amount of money that's owed to the attorney. So let's say the client is really behind or is failing to pay a past due bill to that attorney. The attorney can take steps to try to obtain their fee that they have earned, even if this means filing a lawsuit. This also means that the attorney could divulge certain confidential communications regarding that fee agreement and regarding that breach of their agreement by the client. However, what I do like to point out that even if this attorney is going to take steps to try to obtain their fee that has been earned, in which their client is failing to pay, even though the attorney can divulge certain privileged information to try to obtain that fee, they should only divulge whatever information is necessary to accomplish their goal. So this means that the attorney should not just tell all of the client's secrets. That would not be ethically permissible. The only type of information that attorney could divulge are those things regarding their fee agreement and the breach of that fee agreement. The third exception to privilege says, privilege does not apply in civil litigation between two persons who were formerly joint clients of the attorney. This is a really important one that a lot of people tend to struggle with. So again, turning to our example. It says a lawyer represents clients A and B in a business transaction. Later, A sues B regarding that previous business deal. Neither A nor B can claim privilege to prevent either party from repeating things said between them and lawyer in that previous transaction. What's really important here is that if a lawyer is ever going to agree to a joint representation, that the lawyer takes steps to really explain and to warn this issue to those joint clients. That in the event those joint clients get into some sort of fight and sue each other, they cannot claim privilege against each other. That's a really important thing that lawyer should point out prior to entering into that joint representation agreement. And our fourth and final exception to privilege says that privilege does not apply when the attorney can furnish evidence about the competency or intention of a client who gives or attempts to give property by will or during their life. So for example, let's say a client has a lawyer draft a will, leaving all of its property to one of her two children. Client brings lawyer a list of reasons why she is disinheriting that one child of hers. Upon the client's death, the disinherited child contests the will. Lawyer can furnish evidence of the client's capacity and wish to disinherit that child. That is permissible. So that is privilege. Now you know what is the rule, you know what is not covered, and you know the four exceptions. Let's turn to confidentiality. So we're first going to talk about the general rule. The general rule says a lawyer shall not reveal information relating to the representation of a client unless the client gives their informed consent or the disclosure is impliedly authorized in order to carry out that representation or an exception exists. It's good to know that our rule of confidentiality that we're talking about right now not only applies to matters that are communicated in confidence between, say, the lawyer and the client or the client and the lawyer, but it also relates to all information that's learned while the lawyer is representing the client. It's very helpful to understand that this duty of confidentiality is way more broad than privilege. Because as I stated before, these rules like to test to see if you know the difference. I should say this exam likes to test to see if you know the difference between privilege and confidentiality. So what do I mean? We've already discussed that privilege attaches to those confidential communications between a lawyer and a client. Maybe they're having a telephone conversation or a meeting in person about the case. That communication is privileged. Confidentiality not only attaches to that, because assuming that the lawyer and the client are having that communication in confidence with one another, it would have to be in confidence in order for privilege to attach. But confidentiality also includes those things that the lawyer learns about the client and the representation from other people. So let's say I'm representing a business in a lawsuit. Let's say they're being sued for something. And I'm having conversations with the business owner. Those things would be privileged, are confidential communications. However, let's say I'm reviewing business documents so that I'm preparing well for trial. And I come to learn a lot of very private financial information about this company. All of that information, though it's technically not being communicated by the business to me, because I'm reviewing these documents by myself, so that information is not privileged under the attorney-client privilege. It is confidential in nature. Why? Because it's information that I'm learning about my client and regarding the representation. It doesn't matter its source. So again, if I'm looking at bank documents, that's not attorney-client privilege, but it is confidentiality because it's about my client and it's about that representation. So that is why confidentiality is much more encompassing or much more broad than attorney-client privilege. So now that we know what confidentiality is, it's also helpful to know that our duty of confidentiality lasts forever. It basically survives the end of our attorney-client relationship, and it also survives death. So, you have to continue to keep confidential information confidential, even after your client, say, fires you, or after that representation ends, or even after they die. So now turning back to our rule, we said, looking at the plain language of our rule here, that lawyers shall not reveal information relating to the representation of a client unless their client gives informed consent, or the disclosure is impliedly authorized to carry out this representation, or an exception exists. So this generally means we shall not be divulging confidential information unless your client consents. So this means you would have express authorization to, say, tell someone something about your client or about the case. But you would have to have that express authorization from your client to do so ethically. So this means you go to your client, have a conversation that you maybe need to share certain information with a third party, and they consent. You would be ethically allowed to share that information under those circumstances. The second scenario in which you can ethically share information, specifically confidential information about your client and about your case, to other people, is when you're impliedly authorized. There are two circumstances in which you are going to be impliedly authorized to do this. The first situation is when it is necessary to carry out the representation of your client. That is the first time in which we state you have implied authorization to divulge information. So when, or what type of example or circumstances would you see where you would have this implied authorization? Turning to our example in the outline, it says, in some situations, a lawyer may be impliedly authorized to admit a fact that cannot be properly disputed, or to make a disclosure that facilitates a satisfactory conclusion to a matter. So, for example, let's say a lawyer is representing a woman in a divorce case. This lawyer can admit that the client makes, say, $500 a month selling candles on Etsy, even if this reduces the amount of alimony that, say, this woman is entitled to receive under the law. Why? Because this is an honest disclosure that would be necessary to resolve an alimony dispute. So while that is definitely confidential information, that attorney would be impliedly authorized to divulge that. The second scenario in which a lawyer is impliedly authorized to share client confidences is that lawyers in a law firm, while in the course of the firm's practice, can disclose to each other information relating to clients and matters that the firm is handling. Unless, however, a client has instructed their attorney or attorneys that particular information shall be contained to specific lawyers. So assuming that your client has not given you special instructions, that is kind of the bonus of working in a firm. You can actually bounce ideas off of your coworkers ethically and not be in trouble for, say, violating this rule. But if your client has specifically told you to not share certain information with certain lawyers, then you must follow their instructions. So turning to the plain language of our rule, we know that we shall not reveal confidential information regarding our client and their representation unless they've expressly given you authorization to do so, or unless you have implied authorization to do so, which happens under those two circumstances we just discussed, or unless an exception exists. And there are 6 exceptions here you need to be familiar with. So the first exception, before we even get there, I want to talk about the plain language of the rule. So the language used here is permissive. They use the word may, and a lot of people get this wrong. They think that this may is a must, and that is not correct. So just to repeat myself, all of these exceptions utilize the word may, meaning you may divulge confidential information under these circumstances, but you do not have to, because it's a may, not a must. So turning to the first exception, it says a lawyer may reveal information relating to the representation of a client to the extent that they reasonably believe necessary to prevent reasonably certain death or substantial bodily harm. So turning to an example, it says a lawyer knows that a client has accidentally discharged toxic waste into the town's water supply. He can reveal this information to the authorities if there's a present and substantial risk that a person who drinks this water is going to contract a life-threatening or debilitating disease, and the lawyer's disclosures necessary to eliminate this threat or reduce the number of victims involved. So again, that is a may, not a must. You do not have to go to the authorities under these circumstances, but you can ethically if you want. The second exception to confidentiality says you can divulge client confidences to prevent your client from committing a crime or a fraud that is reasonably certain to result in some sort of substantial injury to the financial interests or property of another person, and in furtherance of which the client has used or is using your services. So turning to an example here, it says, Darren defendant committed fraud, which is likely to result in harm to his company. He goes to his lawyer for assistance in this matter. The lawyer cannot reveal this confidential information if the client has not used or isn't using the lawyer's services to commit the crime. Think about that. The crime already occurred, and the defendant has hired the attorney to represent them in the matter. So the client didn't hire the lawyer to commit a crime. He hired the lawyer to be represented in this case where the crime has already happened. So you cannot divulge confidential information or communications under that example and circumstances. But you can divulge confidential information if a client has used your services to commit a crime or fraud, and if by divulging that information you can prevent it from occurring, then you can. Why? Because it's much like these other rules we've discussed and their rationale before. We want you and our profession to try to avoid breaking the law and committing rule violations. So if we can prevent the law or any rules from being broken, we allow it. The third exception to confidentiality says that a lawyer can divulge information to secure legal advice about the lawyer's compliance with these rules. However, the attorney should not divulge enough information to be able to identify their client. So, for example, an attorney has a question about a client who has committed a hit and run and gave the attorney incriminating evidence to take care of. Attorney calls the ethics hotline in her jurisdiction. Attorney should not state the name of the client and should limit the details to revealing as little information as possible to try to get some help here under the circumstances. So the whole big takeaway is we want lawyers to be able to get help to make sure that they are staying compliant with these rules, which is why most jurisdictions have a hotline, but they should never actually be divulging who your client is. The fourth exception says you can divulge information to establish a claim or defense on behalf of yourself, the lawyer, in a controversy between the lawyer and the client, to establish a defense to a criminal charge or a civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of a client. It's good to know here that we often call this preemptive self-defense. A lawyer does not have to wait until they have actually formally been charged or been sued to divulge client information to clear their name. They can do so beforehand. That's why we call it preemptive self-defense. So an example of this. Attorney has defended a defendant in a larceny case. Defendant admitted to stealing the property that's at issue. Attorney refused to call an alibi witness whom the attorney knew was going to testify falsely. If defendant sues the attorney for malpractice, the attorney may reveal these confidential statements made by the defendant to show the attorney did not, to show why the attorney did not call the alibi witness. The attorney may also reveal this information if defendant complains to the state bar, or even if no formal complaint was not yet filed. The fifth exception to confidentiality here says that lawyers can divulge confidential information to comply with law or court order. So turning to an example here, it would be the scenario where, let's say you are representing your client in a lawsuit. And during discovery, opposing counsel and the opposing party has asked for certain financial information regarding your client. And your client does not want to give that information up. So you file a motion for a protective order or, to try to protect that information from having to be handed over. Let's say you go argue that motion and you lose. The judge decides that this information is relevant and that the other side has a right to see it. So there is now a court order in place requiring you to give that information up. So your obligations here as the attorney should be to consult with your client, explain to them those steps that you have taken, explain to them that you've lost that motion and that you've been ordered to give that information up. You can obviously explain if there's any sort of opportunity to appeal to your client, explore that option if they really are interested in, say, appealing. But if they do not end up, say, wanting to appeal, you would then be able to divulge that information to comply with that court order. And our sixth and final exception to confidentiality here is to detect and resolve any conflicts of interest that arise from the lawyer's change of employment or from changes in the composition or in the ownership of a firm, but only if the relevant information that is being revealed is not going to compromise the attorney-client privilege or otherwise prejudice your client in any way. So we really like law firms, especially if there's been a merger or if, say, a new attorney has joined a firm and brought a lot of clients, to make sure that there is some sort of procedure in place that is being followed to make sure that conflicts of interest have not arisen, or if they do, that steps are being taken to protect information. Oftentimes that means revealing some information about clients to try to detect these issues. And that is permissible so long as the attorney-client privilege is not being broken during this procedure. So that's where we're going to stop with that subsection. Just to recap, I would memorize attorney-client privilege and its exceptions, and then I would memorize our duty of confidentiality and its exceptions. That way, you can feel confident to handle that portion of this exam.